Good morning and welcome to our May 22nd public hearing. We have two items today. Item number 4, ADM file number 2023-36. That includes amendments that would implement the Justice for Kids and Communities legislation and align those with recommendations of the Michigan Task Force on Juvenile Justice Reform. We have two speakers. Our first is Joshua Pease from the State Bar of Michigan Children's Law Section. Joshua, are you with us?
Yes, good morning, Your Honors. And actually, for item number 4, I'm here on behalf of the State Appellate Defender Office.
Oh, I had those flipped. Okay, wonderful. Thanks.
Thank you, Your Honors. So we are here to support this ADM. This has been a long time coming work with SATO and the legislature to get these amendments to the Appellate Defender Act, expanding our mandate to include juvenile delinquency appeals. And this ADM is taking the provisions of the statute and implementing them by a court rule. But there is one important aspect of this ADM I do want to highlight for the court that was not part of the Appellate Defender Act that we believe is an important part of expanding appellate rights for children. And that is creating a 6-month time frame for requesting counsel. Currently, the court rules for requesting counsel in juvenile court proceedings are limited to the 21-day period for which there is a right to appeal. The court rules do not provide for requesting counsel outside of that period, and they do not account for requesting counsel in cases for which there is not a right to appeal. We believe that this limits the ability of children and respondents in child protective proceedings as well to request counsel and to appeal cases if either their request is untimely or if it is not an order that they would have for which there would be a claim of appeal. And we, as in SATO, are aware of at least one instance in which a trial court has denied counsel that was untimely for reasons other than indigency. And we believe that that limits people's ability to test and to challenge issues that would have been raised in the trial court. So we strongly support the ADM as a whole, and in particular, we are glad to see a provision in here allowing for the request and appointment of counsel anytime that there is still the 6-month period for an application or delayed application for leave to appeal. So we would request that the court adopt ADM number 2023-36 in whole. And I'm welcome to answer any questions the justices may have.
Any questions? Great. Thank you very much. And then is Elisheva Johnson from Emergent Justice with us? Do not see her. Okay, that concludes both items, item number 4 and item number 5. ADM file number 2023-36. Let me just double check. Make sure that she's not joining us. Okay, we are all set. Thank you. Thank you all.
Your Honor, I had signed up to speak on behalf of the Children's Law Section on item number 5.
I think you have them. I think you have them switched.
Did I?
Yeah.
Okay.
I started with item number 4, which I thought you were speaking on behalf of the Children's Law Section, and then you to item number 5. So
well, it did have the same ADM number, so that may have been my fault.
No problem. Go ahead, Mr. Pease.
Yes, thank you, Your Honors. So for item number 5, on behalf of the Children's Law Section, again, this is implementing the provisions of some of the bills from the Justice for Kids and Communities Act. There was a number of bills that dealt with screening tools and risk and needs assessments, which we believe are a valuable addition to the juvenile code and will go a long way in assisting children and the courts in dealing with juvenile delinquency cases. But one of the aspects of all those various bills was a provision that indicated that statements made during the course of those assessments would not be used at any adjudication hearing. And we believe that that was a very important addition. These assessments often require discussion of the allegations that may have led to the child being brought into the juvenile court. And unfortunately, the circumstances may be that if the child chooses to remain silent during those assessments regarding the allegations against them, that may increase the risk level that they are scored on those assessments. The addition of that language in these various bills was important because it gives children the opportunity to address what brought them to the court's attention within the assessment without fear that remaining silent will increase their risk level, but also without fear that any statements they make will be taken by the prosecutor and used against them at trial. While those provisions were integrated into the statutes, we believe that it would be appropriate to add a new subrule to the new rule MCR 3.907, indicating, just as part of the court rules as well, that any statements a juvenile makes as part of a screening tool or risk and needs assessment under this rule must not be admitted into evidence against the juvenile at any adjudication hearing. Again, that is already going to be part of the statutes, but we believe that it would be appropriate to integrate that into the court rules as well, given how much regarding the use of the tools and the assessments is already integrated, so that there can be no confusion by the courts or anyone else that what the children say during those assessments cannot be used against them. So we would ask the court to adopt this ADM in full, but with that addition of an MCR 3.907F. Thank you.
Thank you. Any questions? I don't see any. Okay. Now that concludes our public hearing for the day. Thank you very much for joining us, and we appreciate your comments on both matters. Thank you.
Thank you.